I'm Jung-Kay Chiu. I'm a partner and a patent lawyer at Ogilvy Renault. My current practice focuses on patent prosecution, drafting opinions, and also commercial licensing with respect to intellectual property. Unfortunately, it really is sort of a wait and see. There's separate issues, I think, in Myriad that are important to note. The first is their holding with respect to the patentability of isolated gene sequences themselves. That, again, is sort of a wait and see. They took a very non-chemical view of DNA and RNA and took a very informational approach where they sort of equated DNA with information and whether that was markedly different from how it exists in the body. We will really need to see what the Federal Circuit is going to say about that, and almost everybody is in a wait and see mode. I think that the biotech industry as a whole was not particularly shaken by it. I mean, if you look at on the business side, certainly biotech indices and even Myriad's own stock didn't really dip that much when the decision came out, and it regained a lot of it sort of the next day. So I think that kind of shows sort of a confidence in the biotechnology industry. Not the isolated DNA sequences, but certainly on the diagnostic test and the diagnostic procedure. That's where the Myriad decision cited Bilski and looked at whether there was any change or sort of the change or transformation test, and applied Bilski and said that the actual isolated DNA sequences were not patentable. Therefore, under Bilski, because all you're doing is taking something that isn't markedly different from nature and doing these kinds of comparing and determining steps which don't actually change the nature of the isolated sequences in any way other than how it is in nature. They said that there's no change according to Bilski. I think drafting practices will change. It was certainly the vogue before to put in these sort of broad statements of comparing and analyzing in the industry, and those of us that draft and prosecute patents, certainly people are looking to put in more concrete steps of comparing, such as some ideas are, to put in steps that someone would have to do with respect to DNA, such as, putting in some PCR steps or something of that nature. So those are the types of changes that people are thinking about on a practical level when you're talking about drafting patents. All the jurisdictions vary quite a bit in how claims are interpreted and all the rest of it. I mean, obviously, US has always been a very important market, so people keep that in mind when they're seeking patent protection and how to draft their patents and how to seek protection. Canada's fairly slow moving on that point. In Canada, it's fairly loose, so we usually draft in such a way that there's nothing peculiar for Canada. However, in some other jurisdictions, diagnostic methods are not patentable. And that's by legislation, not by application of traditional patentable subject matter. They just say, for public policy reasons, diagnostic tests and methods of diagnosis or methods of medical treatment are outside of the realm of patentability.